Now to that decision on Friday. Giggle for Girls app founder and a trailblazer for all of us women, Sall Grover, is set to appeal her loss in the federal court on Friday, which upheld, this is a full bench hearing, upheld an earlier ruling that she'd unlawfully discriminated against transgender women, so biological man, Roxanne Tickle. The court dismissed the appeal but also doubled the damages awarded against Grover to $20,000. But it certainly got the topic back on the agenda, and I know it's got you fired up. Certainly everyone who shoehorned me on the weekend gave me a piece of their mind. Sall Grover joins me now. I can't be the only one, Sall. I think everywhere you've gone, every comment, every newspaper article I have read, everyone is squarely in your corner. You're going to take this to the High Court. How can we support you?
Thank you so much. I mean, it is true. We have won and are winning in the court of public opinion, but we're always going to, because we're just talking about truth and reality. The other side is talking about ideology and forcing everybody to believe in something that not everyone believes in. So that's always going to be an uphill battle for the court of public opinion. But to win in the court of law is a whole other story, because apparently the court has decided that ideology is more important than reality. So the next step is the High Court. But simultaneously, it is needing politicians to not do something in 2 years, if maybe elected. Girls in school who are not drinking water so they don't have to use the bathroom don't have 2 years. They need this fixed now. I need this fixed now. All women in Australia need it fixed now. Otherwise, we're looking down the barrel of having the Australian Human Rights Commission issue complaints to any woman who calls a man under the guise of gender identity discrimination, and fine countless women and men in this country in keeping us all ideologically held hostage. So the two things that people can do is, one, contact MPs and senators and say, you want this fixed. We need them to know that the majority of Australians, I mean, this isn't even an 80-20 issue, this is a 99-1 issue, want common sense in the law. We just want the definitions. We just want to make sure that everybody is covered in the law. At the moment, it's only this one demographic. And so
absolutely right.
The next part of it is, obviously this has been prohibitively expensive, essentially, for anybody to be able to do it. And I've only been able to do it through the generosity of people supporting me via the crowdfund, which is gigglecrowdfund.com. This cost well over $1 million. I've now been told I have to pay $20,000 in damages and $100,000 in court costs. It's quite overwhelming that something that is classed as public interest litigation and sort of for legislation that needs to be changed, that you can, as an individual citizen, be so punished.
A women-only social media app. A court ruling. 2 Liberal senators demanding urgent law reform. And a case name that, let's be honest, sounds like it was invented by a satirist on a tight deadline. Welcome to Federal Analysis, where Australian politics never stops delivering genuinely interesting material. Here is what happened. The full federal court this week upheld a finding that Giggle for Girls and its CEO Sall Grover unlawfully discriminated against Roxanne Tickle by excluding her from the platform. The court dismissed Grover's appeal and allowed Tickle's cross-appeal, finding 2 instances of direct discrimination and increasing compensation to $20,000 plus limited legal costs. Grover has indicated she intends to take the matter to the High Court. Now, the legal mechanics here actually matter, because this is not just a story about one app. The decision provides guidance on the meaning of the 2013 changes to the Sex Discrimination Act that made it unlawful to discriminate against a person based on sexual orientation, gender identity, or intersex status. That is the law as it currently stands, and the full court has now interpreted it clearly. Whether that interpretation reflects what Parliament intended, or what many Australians believe the law should say, is a separate and genuinely contested question. And that question is now squarely in the political arena. Liberal Senator Sarah Henderson moved quickly after the ruling, calling on the Albanese government to change the law immediately to ensure that women-only spaces are properly protected. Senator Michaelia, the Shadow Attorney General, went further, directly challenging Prime Minister Albanese to amend the Sex Discrimination Act, and offering the coalition's full support if he did so. Cash pointed to New South Wales Premier Chris Minns, who has publicly stated his view that biology matters and that sex should be defined as the biological sex a person is born with, as an example of the kind of position she would like to see reflected in federal law. Coalition leader Angus Taylor has also stated clearly that he believes biological sex matters in the context of rights frameworks. The Australian Human Rights Commission, by contrast, welcomed the court's decision, describing it as providing important clarity about the protections against gender identity discrimination. Equality Australia also noted that the ruling made it easier for people to establish direct discrimination claims under the current framework. So here is where things genuinely sit. The court has applied the law as written. The question now before politicians is whether that law needs to be rewritten, and if so, how to balance protections for transgender Australians with protections for single-sex spaces that many women's advocates argue are essential. That is a real legislative debate, and it is one that Parliament will increasingly have to engage with rather than defer. The Albanese government has not yet indicated whether it will pursue any changes to the Sex Discrimination Act. That response, or the absence of one, will be the next chapter in this story. If you want sharp, clear breakdowns of the legal and political stories shaping Australia right now, subscribe to Federal Analysis and drop a comment below. Where do you think the line should be drawn in Australian law on this one?